Me Dardanella. I love your hair and eyes. He loves your hair and eyes. A lucky fella to capture such a prize. But when I lose my love for you, yeah, you know that I'll be true. Alrighty. So, I don't remember where I left off in DeCastro versus Abrams. I think I left off on their motion to file a reply. I probably did Chili's opposition, which I think I said was a futile opposition. So, good morning. Good morning, Chris. Good morning, Delete D Lols. Good morning, Jonathan. Good morning, Christine. Good morning, Maggie K. And you're not alone with me, Maggie K. So keep it PG, girl. Keep it PG. Why aren't you at Freeman's barbecue protesting? Because I wasn't invited. That's why. So I think I left off with Chile's ill-fated opposition. So we are going to look at the reply. Defendant Google LLC's reply. Oof. 11 pages. But it appears that most of it is fluff, so that's good. All right. Plaintiff cannot avoid transfer by ignoring Atlantic Marine. Yes, that is one of Chile's big issues, is that if he doesn't like a case, instead of actually finding a case that either distinguishes it or that overturns it, then he just ignores it. And it's really going to be hard for him to overturn Atlantic Marine since it is a relatively recent United States Supreme Court decision. So, yeah, oopsie doodles. The parties agree that YouTube's terms of service constitute an agreement between the YouTube and the plaintiff that all claims arising out of or relating to these terms or the service will be litigated exclusively in the federal or state courts of Santa Clara County, California. Plaintiff does not dispute that. In addition to expressly accepting the TOS when creating his YouTube channel on July 28th, 2020, he agreed to the same forum selection clause again when he agreed to the YouTube Partner Program terms, which allow him to earn ad revenue from YouTube's service. Plaintiff nonetheless makes two arguments against transfer, both of which fail. First, plaintiff argues that his claim against Google falls. His claims fall. Okay, there you go. They were right. I was wrong. Plaintiff argues that his claims against Google fall outside the scope of the forum selection clause because they're not claims between users of the service and YouTube related to the products and services that YouTube provides the users. To the extent that argument is comprehensible, it is wrong. That's a burn. That is a burn. Now, you got to be really careful with throwing burns in on your pleadings. The court can take it one of two ways. The court can either be like, yeah, you're right, that's kind of funny, or the court can be like, look, bro, that's not cool. He is a pro per plaintiff. He doesn't understand, and you don't need to rub his nose in the dog poop. All you have to do is argue against it. Plaintiff concedes his claims are, quote, related to YouTube's, and then they put in alleged failure to take appropriate action for copyright infringement on its platform. More specifically, he alleges that Google is liable for YouTube users copying videos onto YouTube they'd previously uploaded to YouTube. Yeah, it was incomprehensible. Such claims obviously, clearly arise out of or relate to the YouTube terms of service, okay, and are indistinguishable. No, he was right. Again, I was wrong. He was right. I was wrong. And are indistinguishable from other copyright claims that were found to be covered by YouTube's forum selection clause, e.g., Kiffle versus YouTube. Plaintiff makes no effort to distinguish the cases that broadly interpret YouTube's forum selection clause to cover such cases. Yeah, he does not distinguish jack shit. Second, plaintiff invents a new legal standard that directly contradicts Atlantic Marine. He wrongly asserts that forum selection clauses can only be invoked by a, quote, necessary party. They do not apply if they would cause unanticipated inconvenience, and the burden is on the party seeking to enforce the clause. None of that is true, and plaintiff makes no attempt to distinguish the ample case law Google cites to the contrary. That is true. I think the claims or the things that the citations that he raised about the necessary party rubric did not support his position. They were in fact antithetical to his position. The argument that it was unanticipated that a breach of contract would occur and thus require him to sue Google. That is also an idiotic argument, and that the burden is on Google, which is also an incorrect statement of law. Plaintiff cannot prevent dismissal by registering one work after filing suit. To survive a motion to dismiss, a copyright plaintiff must register the allegedly infringed works before filing suit. Now, I think they can pre-register it. There might be another. I don't think it has to actually be registered. I think it has to be at least in the process of being registered, if I remember correctly. I could be wrong. I'm not a patent attorney. Listen to oh God, what's his name? Lawrence something or the other. Why do I want to say Lawrence something or the other? There's a patent lawyer on YouTube who God, I'm drawing a blank, and Chad isn't helping me out, so I don't remember his name right now. But there is a copyright lawyer, and I am not him. It has to allege. Yes, he does have to allege that registration has been obtained prior to filing suit. I believe also, or that it's in the process. Leonard French. Thank you, Mary Smith. So I believe that it can be in the process of being registered. There's like this pre-registration status that it could be. And, quote, plausibly allege, end quote, that the copying of the copyrighted material was so extensive that it rendered the infringing and copyrighted work substantially similar. Plaintiff's complaints do none of these things and fall far short of basic pleading standards. See Iqbal. Making conclusory allegations, alleging that all defendants, including unknown ones, are responsible for unspecified infringements. Yes. Lawful masses. Yes, that is correct. Don't give up the day job. I won't. Trust me, I won't. It pays way more than this, since this doesn't pay me anything. Plaintiff nowhere alleges that he registered any copyrighted work and concedes. So this is a slightly technical argument. He has to allege in his complaint that he registered copyrighted work. It doesn't matter if he proves that he has subsequently registered one. He has to allege in his complaint that he registered a copyrighted work and concedes, as he must, that a copyright claim can be dismissed for not having alleged that the copyrights have been registered. He actually said that? Opposition at 4, huh? I'll take their word for it. I think I might have remarked on that. This requires dismissal. Citations. Plaintiff nonetheless seeks to avoid dismissal because Google has, quote, joined the party a bit late and the other parties never raised the issue, which I believe I concluded or I proved about the other parties that it was wrong. Josh Abrams' attorney Garrick has raised it, and this was the first opportunity that Google had. Supposedly because plaintiff chose not to name Google as a defendant until a supplemental complaint, it is now too late to point out his failure to register any copyrighted work. Nonsense. Google is raising the issue at its first opportunity in support of its motion to dismiss. Plaintiff's only other argument relies on a new fact not alleged in any complaint. The plaintiff has, quotes, has successfully and completely registered at least one key video, end quote. But an argument unsupported by factual allegations cannot prevent dismissal. So what I foresee happening, and you could tell me how dumb and wrong I am, is that the court is going to grant the dismissal without prejudice so that Chile can refile in the Northern District Court in California. That's my best guess at this point. When a plaintiff argues facts in opposition that are quote or that quote are not alleged in the complaint, the court considers them only for the purpose of determining that it would be futile to allow plaintiff leave to amend his complaint. Yeah, because in a motion to dismiss, it's what's in the complaint that's at issue. It's not the actual facts. It's not the ultimate facts of the case, but it's what is alleged in the complaint that is at issue. Easy, ladies. Plaintiff's belated argument does not even justify allowing him leave to replead because he has only ever registered one video and did so after he instituted the civil action violation of 17 U.S.C. 411A. His failure to register any alleged infringed work prior to bringing a lawsuit requires dismissal. And he cites a Supreme Court case with a strange citation. He doesn't cite it, the U.S. one. Wow, how about we do it this way? Why does he use this citation instead of the U.S.? Because it doesn't have a full cite in the U.S. And what are we looking for? Registration is akin to an administrative exhaustion requirement that the owner must satisfy before suing to enforce ownership rights. Plaintiff's failure to satisfy Section 411A renders futile any attempt to file an amended or supplemental complaint. So here's this Cortez Ramos v. Martin Morales decision. And again, he's not citing it for the case itself. That's very important. He's not citing this for anything in this opinion, which is apparently a district court decision. He is citing it for the collection of cases that are cited in this district court opinion. There were some people discussing this case on my Discord this morning, and I have not been able to find this case because I'm not going to pay for a LexisNexis account. And I guess I technically could look it up in Pacer. But I know there's a bunch of Cortez Ramos versus Martin Morales cases out of the District Court of Puerto Rico. So I don't want to take the time to do it. But anyway, it is an important thing to note that this case is being cited for the collection of citations contained in it. It's not cited for the case itself. It's cited for the collection of cases cited in it. It's a shorthand way of citing all the cases that are cited in this case. Very important distinction to make. Allowing plaintiffs to draw out this litigation would only validate a strategy by suing on hundreds of unregistered works and then registering him one by one as needed. This would undermine Fourth Estate, and they're citing Roblox, which is a district court decision out of California, the Northern District of California, and make meaningless formality out of Fourth Estate's requirement that an application be approved prior to filing suit. And that is another district court decision. See also another district court decision. So there are a bunch of district court decisions at this point citing Fourth Estate. And I'm guessing that it is because Fourth Estate was not published until 2019 that something hasn't gotten there yet on it, or something along those lines. So, see, decided March of 2019, which means that the opinion could not have been, the syllabus could not have been published until 2019. Allowing plaintiff to sidestep Section 411A by filing amended or supplemental complaints would also be inconsistent with the text of the Copyright Act. As Judge Breyer held in a similar case, by typing the registration, words are hard, man. You don't have to use Lexis to view that case. Well, why don't you post in the chat the link to where I can view that case, where I can view that particular opinion, and then I'll believe you. By tying the registration requirement to when a civil action is instituted, the plain language of Section 411A refers to the beginning of a lawsuit, not the filing of an amended pleading. And he cites a United States Supreme Court decision. See also this district court decision. Plaintiff granted YouTube a broad license covering all works in suit. As noted, plaintiff does not dispute that he agreed to YouTube's terms of service, which states that by uploading his videos, he gave YouTube a worldwide, non-exclusive, royalty-free, sub-licensable, and transferable license to use that content, including to reproduce, distribute, prepare derivative works, display, and perform it in connection with the service and YouTube's business. Nor does he dispute that, under the plain language of the license, YouTube cannot be liable for directly infringing any copyrights associated with any content that plaintiff has uploaded to its channel, end quote. And they are then citing a district court holding that has an appeal docketed. So, interesting. This is grounds for dismissal of plaintiff's claims, which are based on alleged infringement of videos that plaintiff himself had already uploaded to the YouTube service, subject to the license. That is an excellent point. Plaintiff offers 2 make-weight arguments. That is a new word for me, and I am going to Google it. Make-weight. Put something on a scale to make up the required weight. An extra person or thing that is only added or included in order to complete something. Use it for casserole toppings or make weight in meatloaf. Today I learned. Make weight. It's such a simple thing. One would have thought one would have heard it previously. Plaintiff offers 2 make-weight arguments against dismissal on this ground. First, he claims, the key video in this litigation was never published on YouTube, end quote, and therefore is not subject to the license. But plaintiff cannot save his claims by introducing a surprise unpublished video in his opposition brief. In addition to being unalleged, this directly contradicts his existing allegations, which make it clear that, or that all works in the suit were, published as content to plaintiff's YouTube's channel. I'm not going to go to the supplemental complaint, but these things always trigger me a little bit, where he has bolded and italicized all, but he doesn't quote it. So, did Chili say that all of the works that he's suing over were published as content on plaintiff's YouTube channel? Is he saying that? Or did he say something else? And YouTube is implying that he said it. I really want to look it up now. We are going to look it up. The supplemental complaint. Oops, I didn't want to do that. We're going to do Control F, supplemental complaint. There we go. Bad boy. And so he's alleging that he published over 800 videos on his YouTube channel. And that's the only mention of published. That's it. There's no other published. But he also doesn't mention any videos published elsewhere. So that is a bit of a argument by Google there. That's not necessarily fatal or anything like that, but it does get you to think sometimes. You know, it might draw attention to it that they didn't want. And then we were looking at the reply. All right. And we're going to get back up in here. Up in here. Get up in here. Published. Publishes content to my, yeah. None of plaintiff's works are identified in any of his complaints except by a YouTube URL. That is true. Second, plaintiff attempts to distract from the broad license he granted YouTube by instead quoting the license he granted to other YouTube users. Compare motion at 5, quoting license to YouTube, with opposition at 4, quoting license to other users in his declaration. This is misleading. The existence of another license does nothing to change the terms of the license YouTube relied upon by Google in its motion. And therefore, they asked the court grant its motion, transfer the case, or dismiss without leave to amend. Well, Cheeky Monkey, why aren't you posting that link, buddy? Why aren't you posting that link? You're still in here commenting. You said you don't have to have Lexus to view the case, but you're in here commenting without a link. I feel like you're misleading me, Cheeky Monkey. I feel like I've been lied to. All right, then we got a motion for leave to file a surreply. I'm sure this will be a very well-written and informative motion. So he wants to file a surreply. Motion to file a surreply. In support of his motion, he submits this memorandum of law. If allowed, the reply be no more than 5 pages and will be submitted by June 22nd, 2023, or within 7 days of the court's order, whichever is later. Most of the arguments in YouTube's reply require little response, as their defects are readily apparent. Clearly, they're defective. Clearly. See reply at ECF 127, where YouTube puts evidence on the record showing that plaintiff has works, plural, registered, after arguing that plaintiff doesn't. See, he can't post links in the chat. Why can't he post links in the chat? I don't have any restrictions on anything like that. Do the little thing where you post the link, except you put in, like, you write in dot instead of the whatever. So all right. So first of all, YouTube didn't put in evidence in the record. They responded to him, to Chili, alleging that Chili had registered one work. So they weren't putting evidence on, and it's not evidence on the record. They are responding to Chili's allegation that there is a registration, and they are telling the court that they're not denying that there is now a registration. It is not evidence on the record. Sovsits love this on the record stuff. This is motion practice. This is law in motion. This isn't putting evidence on the record. Putting evidence on the record would be like at a trial, at an evidentiary hearing, where you offer evidence to be admitted into the, or you ask it to be admitted into essentially the court's record of the trial. There's the clerk's transcript and there's the court reporter's transcript. The clerk's transcript will usually have the evidence that was posted without HTTPS might work. I don't see it. All right, so we are going to, how do I make you a monitor? I don't know how to make you a monitor or moderator. I don't know how to make people moderators. I don't have moderators, so I don't know. I don't know. I'm just gonna ignore it for now. Post it in the comments of the video or something, because I don't know how, Sean. I don't know how. Okay, you'll email it. All right, I will open up my email. Send it to the merb34st@gmail.com email, please. All right. And thank you. I appreciate you bearing with me through all this nonsensory. I am a boomer and I have boomer tech skills. You're welcome. All right. So there is no evidence in the record. They are responding to Chili's allegation that he has now registered at least one video. He made the allegation. They say they're not contesting it, that they verified it, and that's it. That's it. They're not putting evidence on the record. And what their argument is that Chili did not allege that he had registered a copyright. He didn't allege it. And even if he did register a copyright, he only did so after he had filed the lawsuit. So it's defective in two ways. That's what they're arguing. So he is misstating their argument. Now, whether he did so intentionally or otherwise, I don't know. But he is misstating it. So he says at least two defendants' arguments are worth addressing in a short reply. Number one, defendant YouTube tries to cure deficiencies in its motion. I didn't see that. What deficiencies are they trying to cure? He says, however, reply papers may only address issues raised in the moving papers. A reply paper addresses issues raised in the opposition. That's what a reply is for. It's to address issues raised in the opposition. You have your initial motion. The opposition can raise whatever objections they want, or opposing law and fact that they want. And then the reply is to address, distinguish, argue against whatever facts and or law that the opposition raised to the motion. So by default, a reply is not just to rehash the arguments that you made in your motion. That would be stupid and a waste of everybody's time. The point of a reply is to address the allegations of fact and law that are raised in the opposition. So I don't understand what he's trying to say there. It is improper to introduce new facts or a different legal argument in the reply brief. To the Googles. All right, and he says this was at 894 to 895. Oops, 894. All right. So in this particular instance, the Court of Appeals relied upon supplemental affidavits. That's different. So the Court of Appeals, in an appeal, has to rely on the record in the district court. They have to assume the facts is true in the district court. In this particular case, the Court of Appeals relied upon supplemental affidavits that the district court declined to admit. The district court had issued an order directing respondent to file a supplemental memorandum. It did not call for new evidentiary materials. Okay. All right. So the respondent supplemented additional affidavits. YouTube did not introduce additional facts when they were ordered to file a supplemental memorandum. That would be a memorandum of law. So no, they didn't introduce new facts. I don't know what he's arguing about there. And then we've got, what are we doing here? We've got this particular case. We've got U.S. versus Rel Giles versus Sardi. And we're 1127. 1127. So let me search for it by that. Cock-a-doodle-doo, bitches. 126. All right, we're at 1127. New arguments asserted in a reply brief. It is improper for a moving party to introduce new facts or different legal arguments in the reply brief than those presented in the moving papers. City asserts in its reply that the state of the proceedings would be appropriate in light of pending United States Supreme Court decision, etc. It is not clear to the court, however, that the Supreme Court's decision in the case will impact the issue in the present case. Specifically, while the Supreme Court may address the issue of whether a state is a person under the FCA, it is not clear that it will reach the issue of whether a municipality is a person under the FCA. New arguments in favor of dismissal based on its theories of constitutional standing, etc. The Ninth Circuit has previously held, however, that FCA's qui tam provisions do not. All right, I'm going to need a little bit more understanding of the underlying facts of this case. So the defendants filed a motion to dismiss the first amended complaint. Earthquake, state of emergency. Boo, doo, 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 doo. So she filed her original complaint in the action under seal and served on the United States a written disclosure. Her attorney filed the first amended complaint naming the city as a defendant. On March 11, 1999, the United States filed a notice of election to decline intervention. Okay. So it's just her versus the city. So the city filed a motion to dismiss the first amended complaint. Several other defendants also filed a motion to dismiss the first amended complaint. The U.S. filed an amicus brief. Then she filed her opposition to the city and the other defendants' motions to dismiss. The city then filed a reply to the realtors and amicus opposition briefs. So the U.S. and the plaintiff filed objections. And then a defendant filed a motion to dismiss. They granted Giles's, the plaintiff's, ex parte motion for leave to file an opposition to Mitchell's motion to dismiss. And then Sardi filed the motion to dismiss. The motion has not yet been opposed. However, because Sardi's motion mirrors the city's and Dixon's motions, the court will address it here and incorporate Giles's opposition, the plaintiff's opposition. So the issue here is that the city had filed a motion to dismiss, and then in their reply, they are arguing for a stay of the proceedings, which is different than a motion to dismiss. But then they offer two new arguments in favor of dismissal. So the issue is here is that they didn't raise these arguments in their motion. They're not responding to oppositions. They didn't make these arguments in their initial. All right, how do I explain this? Google's not offering a new theory for why they should get the transfer in their reply. They're still relying on the same case and the same theory, i.e., that the terms of service are binding on Chile, that the Northern District of California is the appropriate district for this case to be heard in. That is not a new argument, and there are no new facts that they're alleging in support of it. They're distinguishing Chile raising a different term of service or a different portion of the terms of service. They're still relying on the same terms of service to support their motion to transfer venue. The other argument that they're making is on their motion to dismiss. They're citing the same cases. The Cortez cases, they were citing that in the initial pleading. It's still the same legal theory. The legal theory is that Chile did not allege in his initial complaint that he had a copyright. Now he's saying, well, but I do have a copyright. And they're saying, well, fine, but you didn't allege it, or you didn't have it before, and you didn't allege it in the complaint still. So just because you got it afterwards, it's Chile who raised a new argument. They are just responding to the new argument. They're not raising one. They're just responding to it. And the theory behind that is that your motion has to set forth the basis of your legal right to whatever it is. The opposition is based on that motion. Normally, it ends at a reply. Normally, it's motion, opposition, reply. So if you raise a brand new argument in your reply that is new and novel and is unanticipated by the opposition, then the opposition doesn't get an opportunity to respond to it. Normally, a court does not grant a surreply. That's normally not the case. So that's where he's going wrong. A party waives issues and arguments raised for the first time in a reply brief. Yes. Since YouTube did not raise in its motion the argument that the copyright registration was untimely, YouTube's argument for untimely copyright registration is itself untimely and should be disregarded. That is a shitty argument. And I'm going to tell you why. The court's going to say, wait a minute. How would Google have had any notice that any of your works were registered? Because you never made that allegation, Chile. So basically, Chile saying that because Chile hid the ball, because Chile didn't tell them that he had this valid registration that he got after the case was filed, then all of a sudden YouTube can't respond to this new information. That's bullshit. Chile should understand how bullshit that is. I don't know if he can, but he should. Even if YouTube is allowed to inappropriately raise the alleged, quote, untimely copyright registration of plaintiff's video, the video is actually registered prior to the second supplemental complaint where it is mentioned, so their argument is irrelevant. Did he mention it in the second supplemental complaint? Abrams. All right, we're going to shaw this top and stud saw. And we're going to go to supplemental. And now we're going to look for register. This is the supplemental complaint. You saw me go here. This is the supplemental complaint. We're looking for where he alleges in here, anywhere in here, that he has a registered he doesn't mention registered anywhere in here. So I'm going to go with so it's mentioned. He doesn't mention any registered. I do not understand this at all. He doesn't talk about any specific video. He talks about over 800 videos. Content isn't necessarily singular. It could be any and or all of the 800 videos. A fun thing is that I actually have a one of my videos still taken down by DeCastro, which I think is hilarious. This is a tangent. We're on a tangent, folks. And we're going to go to from. As a file. So one of my videos is down. He took this down months ago, and so I sent over a new hey, what's going on with this? And because it's been down for it's been down since like November, I think. And it says, hey, thank you for submitting your counter notification. As part of the counter notification process, the claimant must provide evidence of legal action taken to keep the content from being reinstated on YouTube. Attached to this email is the evidence we received from the claimant. That link, that PDF that they gave, that they show, is the DeCastro versus Abrams. I'm not a named defendant on that. That is so weird to me. That is so weird to me that they accepted Chili's allegation that apparently I'm a John Doe. So weird to me. Anyway, so it wasn't. So Chili's lying. It was not mentioned. No registration was mentioned in his supplemental complaint. He says YouTube doesn't support the legal basis of their untimely copyright registration argument anyway. Doesn't support the legal basis. YouTube doesn't support the legal basis of their untimely copyright registration argument anyway. Yeah, they did. They absolutely did. All right. So then he says Cortez Ramos versus Martin Morales, U.S. District Court opinion, is an unpublished case that YouTube cites that they cited for the purpose of collection of cases. Merb, what would you do? What would you do if Chile named you in the California lawsuit? I would defend it. I would introduce Chile to the intricacies and nuances of discovery in California. That's what I would do. So YouTube cited a bunch of cases in support of in their reply brief. Do 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 do. Bum, ba-da, ba-da, ba-dam, bow. All right. Whoops. You're looking at what I'm looking at. Share this tab instead. Okay. All right. So can't ignore Atlantic. Can't prevent dismissal by registering one work after filing suit. So in support of this, they cite Foss versus Marvick, which is a First Circuit case, the appropriate circuit. They cite Cortez Ramos versus Martin Morales. This is another First Circuit published Court of Appeals decision, which is the appropriate circuit. They cite Kenny versus Warner Brothers, which is a District Court of Massachusetts decision, but it is a published decision, quoting another First Circuit Court of Appeals decision. They quote the plaintiffs quote Iqbal, which is a United States Supreme Court decision, and they cite Fourth Estate, which is a published Supreme Court decision. They quote or they cite Padula versus Freedom Mortgage, which is a district court decision where the judge was Burroughs. So they're using the judge's legal reasoning. Google's using the judge's legal reasoning. So the judge is going to agree with her own legal reasoning. They cite Azevedo versus U.S. Bank, which is another Judge Burroughs decision. These are all Judge Burroughs. Like, I don't even understand. Like, what is he going to do? And so the only reason they cite Cortez Ramos is, again, the district court decision is for the collection of cases. They cite Roblox, which is an unpublished case. They cite Malibu Media, which is an unpublished case, and May Larson Designs, which is an unpublished case. Keifel, unpublished case, and Hardwell, unpublished case. So they cite lots of published cases and lots of unpublished cases. But the only reason why they cited the Cortez Ramos district court decision, the only reason why they cited it is because it is a collection of cases. It is a shorthand cite to multiple cases. That's the only reason why they cite it. But that's the one case that Chile apparently is going to take exception to, is the case that they don't cite for the actual reasoning in the case, but they just cite it for the collection of cases that it cites. So then he says it's an unpublished case where it was decided. So Chile, instead of understanding that it is only cited for the collection of cases that it cites, he's going to actually talk about allegedly what they discussed in the case itself. Let's see. And Cheeky Monkey still hasn't emailed me that link, or at least it hasn't shown up. Let's see if it is caught in, because I kind of want to see the case now. Spam. Oop, oh, I see it. All right. Google link. All right, we're going to do that one and that one. Okay, so share this tab and set. All right, so here's the problem. This is the published Court of Appeals case. This is not the district court opinion. So you see how it says right here, this is a U.S. Court of Appeals, so that is the wrong case. And this one is also, well, it's the wrong decision. These are both the Court of Appeals decision. This case, or this opinion right here, is the district court opinion. So sorry, Cheeky Monkey, but it didn't work. It didn't work, bro. Did not work. Wrong links. You want to try it again? All right, I will let you try it again. All right. Instead, it was cited the action. All right, so where in it was decided that where a copyright holder had filed a registration late, the district court should not have dismissed the action with prejudice. I don't think Chili's actually read the case, the opinion, the district court opinion, because the district court is the one who decided in Cortez Ramos to do whatever they decided to do. An appellate court would have come back later to decide whether or not the district court erred in what it did. So I am 95% positive right now. Could you get that opinion straight off Pacer? Sure. If you could find it, Jeff, if you could find it. It would be number 16-1223, but that doesn't look like a normal site. It looks like it is this right here. Oh, you can't probably see it. It looks like it's that copy. The opinion is on case text. That looks like the site. Oh, it's 3:16. There we go. The opinion is on case text. Second try. All right. Well, we'll do this. Open in a new tab. Let's see what we got here. Share this tab instead. All right. So this is an opinion in order from 2022. So again, that's fail train. Sorry, Cheeky Monkey, you're 0 for 2, because if you see, the opinion that we're looking for is a 2020 decision. So oopsie doodles. That's strike 2. Did you want to try strike 3, or you got any more in you? Is really what I'm asking. You got any more in you? You want to go for another round, Cheeky Monkey? You want to go for another round? All right. So I believe what he's citing is he's citing the Court of Appeals decision, or the Court of Appeal. You got all day? Nice. Instead, it was decided the action should have been dismissed without prejudice. Okay, but I'm not going to go into. Chili's analyzing the wrong case, and so I'm not really going to get into that. Additionally, Cortez Ramos ultimately relies on, at Section 9, a district court case. It's a collection of cases. At paragraph 9, a district court case in the Second Circuit I don't know what he's on about. Let's look up, since we have it. We're gonna do this over here. Without. All right. So apparently, at least in the Court of Appeals case, or the Court of Appeals decision in 2020, which most likely followed the district court's opinion, says the district court dismissed Cortez Ramos's state law claims without prejudice. It held that the Puerto Rico Trademark Act failed. Generally, when a plaintiff's claim is dismissed for failing to satisfy a pre-suit requirement, the dismissal should be without prejudice when the plaintiff may be able to satisfy the requirement in the future. There appears to be no dispute the Copyright Office registered his music video after he filed his complaint, and thus he could allege registration in a new action. So they're talking. The Supreme Court said that registration is not a jurisdictional requirement, but a claim processing rule, akin to the exhaustion of administrative remedies. So here the court dismissed without prejudice. The Court of Appeals is sending it back to the district court to determine whether or not they should dismiss it without prejudice, because they have the discretion to do it, at least in this particular second district. This is the second district? First district case. Okay. So, boy, if Chile actually wanted to make a good argument, he would say, "Hey, look, in this case, it said that the court has a discretion. The district court has a discretion that they can just allow him to supplement it." Why didn't he make that argument? I don't know. Madonna. All right, so we're looking at Malibu Media 2019 is Are You? Maybe share this tab instead. All right, so we are going to look for all right. The first question is whether a plaintiff that improperly filed suit before a copyright register can cure that defect. The court holds that such prematurely filed suit must be dismissed, notwithstanding a plaintiff's post-registration amendment. Well, must. So why is I didn't see any mention of that particular case in Cortez. Let's check it out, though. Malibu. It's not cited in the. Well, I mean, they don't cite Malibu here in the First Circuit Court of Appeals case. So I don't know what he's going for here. I don't know what he's going for here, and I couldn't find that particular quoted language. I don't care. I don't care. I don't care if anybody likes it or not. That doesn't matter to me. Finally, YouTube's argument is moot. It's moot in general. In general, courts have agreed they lack the jurisdiction to make a ruling on a moot issue, but have only done. Why is it moot? Why is it moot? Why is it moot? It's moot. Okay. Well, why? I don't know. Plaintiff never published the key video in its complaint. YouTube says that this fact contradicts plaintiff's first amended complaint, but the key video in this complaint was not mentioned until plaintiff's request to make a second supplemental complaint. It is also mentioned in the second supplemental complaint itself. Second supplemental complaint. Okay, let's file a second supplemental complaint. Second supplemental complaint. Okay. Wait, that's the wrong. So I'm gonna do this one here. Second. Ooh, I don't want to put a bookmark in. That is crazy. Second supplemental complaint. Okay. All right. Infringement of my copyright works have been published, including but not limited to, and then these are all YouTube links. What am I missing? These are all YouTube.com links. They're all YouTube.com links. Plaintiff never published the key video in its complaint. He doesn't identify what the key video is. YouTube says that this fact contradicts plaintiff's first amended complaint, but the key video in this complaint was not mentioned until plaintiff's request to make a second supplemental complaint. It is also mentioned in the second supplemental complaint itself. All right, let's look at the motion. All right. Oop, you guys aren't seeing this. All right. I don't see any mention of a key video. I don't see any mention of a key video. I have no idea what Chili's talking about. The video is obviously not mentioned at all in the plaintiff's first amended complaint. Yeah, it's also not mentioned in the second supplemental or in the motion for the second supplemental. I don't understand. Even if it was published on YouTube, even, which plaintiff denies, YouTube does not dispute that their TOS only applies to products and services that YouTube provides to a user of YouTube service. YouTube would have this court believe that allowing third-party users of YouTube to copy plaintiff's creative works is a product and service that YouTube provides to plaintiff, which is unconscionable. Allowing YouTube's users to copy plaintiff's works is not a service provided to plaintiff. I need a beverage. I will be right back. All right, we have achieved a frosty cold beverage. So assuming it was published on YouTube, YouTube does not dispute that TOS only applies to products and services that YouTube provides to a user of YouTube service. Yes. So if you publish a video on YouTube, you grant YouTube a license to display it and to monetize it and all of that other fun stuff. Well, Chili granted a license to them to monetize it and to display it. So it does apply to products and services, i.e. video hosting, that YouTube provides to the person who hosted the video or who uploaded the video. Yes. YouTube would have this court believe that allowing third-party users of YouTube to copy plaintiff's creative works is a product and service that YouTube provides to plaintiff, which is unconscionable. No, they're saying that you can't sue them. They're not arguing that anybody can publish your videos. They're not arguing that. They're arguing that you can't sue them for it. You gave them a license. So you can't sue you. They're not saying you can't sue a third party. They're saying you can't sue them. That's the whole point of the DMCA stuff, is that you issue a copyright strike. If the other party doesn't oppose it, then the video comes down. If they oppose it, then YouTube takes a video down for approximately 15 days, giving you time to file a lawsuit. And if you provide evidence of the lawsuit against the third party, then YouTube will keep the video down. So YouTube understands its role in the DMCA process. Chili's argument is just mind-bendingly stupid. YouTube continues to be oblivious to the fact that they were joined in this action. They weren't joined. They were named as defendants. They were not joined. You join another party with a motion for joinder, and then you can join them as a necessary party. Generally speaking, it's like if you sue a defendant and the defendant says, wait a minute, I can't figure this out. I can't help you. Like if it's like an estate issue or something like that, or a trust issue where you're the trustee and someone is suing you, you might have to join the beneficiaries of the trust or the beneficiaries of the estate, because they have a legal right and claim to this, whatever is being disputed over. So like, let's say there's a car and you're the administrator of the estate, and someone sues you and says, that's my car. And you've got to be like, well, hold on a second. I need to join the beneficiaries of the estate, so that, because they have right now a claim to this car. So I need them to be part of the suit so that everybody gets their, I don't want to sue the beneficiaries to get them in with a counterclaim or a cross claim, countersuit or a cross claim, but they need to be part of this action. That's what joinder is. Chili didn't join Google. He sued them. They're not joined. He named them as defendants. They're not joined. Another fairly common thing for joinder is like in family law. A lot of times an employee benefits plan will be joined into the action so that the court can issue orders regarding the benefits plan. And because the benefits plan also has like a cognizable legal right to limit the plan to employees, they need to be joined so that they might want to oppose it. But generally speaking, they don't. But that's another issue. Like, that's what joinder is for. You're not suing the person. You're suing them is not joining them. If you file a cross complaint or a counterclaim against another party, against a third party, they're not being joined. They're being sued. Words have meanings, and Chili doesn't understand the meanings of the words very well, unfortunately. So they're not joined. They are defendants. YouTube is trying to abandon this action so that those users must take on YouTube's portion of the damages. No, they're saying that you sued them, and they're trying to get this moved to the Northern District Court of California, which is the appropriate venue for it, considering that you signed a TOS agreement with them. It is possible, which is a stupid thing to say. You should say this is or this isn't, but not it's possible. I mean, that's just speculation. It's possible that YouTube user defendants in this action may need to make their third-party claims against YouTube under a forum selection clause because YouTube or between YouTube and those defendants. However, YouTube has not made that argument or provided evidence that those defendants agreed to the TOS. Instead, they purposefully mischaracterized plaintiff's complaint. No. The only person who's mischaracterized plaintiff's complaint is plaintiff. He's alleging that he said things in it that he obviously didn't say. So I don't understand any of this. Again, YouTube should be at least required to read the complaints in their entirety and plead relevant arguments, but so far its motion to dismiss lacks any merit. Well, that's conclusory and stupid. Plaintiff should be allowed to amend its complaint, but if plaintiff cannot amend its complaint, only the claims in plaintiff's first amended complaint will be lost. But the first and second supplemental claims will survive as well under 17 U.S.C. 501, which don't require registration according to the statute. I don't even understand this. Load. I wonder if I have connection since this is taking so long to load. Am I still online? Oh boy. Oh boy. That one worked. All right. So this is 17 U.S.C. 501. Anyone who violates any of the exclusive rights of the copyright owner as provided by sections 106 through 122 of the author, blah, blah, blah. For the purpose of this chapter, any reference to copyright shall be deemed to include the rights conferred by section 108A. So you have to violate the exclusive rights of the copyright holder. Oh, F you, Westlaw. Why don't you load? Give me a good one to look up. You bastards. Do. I don't want Lexus. I want. All right. That looks like it requires registration under section 411 to me. I could be wrong. So apparently does require registration under the statute. So oops. So she granted him leave to file a reply. Didn't we just go through this one? Holy Jesus. Defendant's wrong court argument. YouTube does not dispute that TOS only applies to terms of service. That's the same stupid argument he raised in his motion for leave to file the reply. I don't understand why he says YouTube is not necessary. They're a defendant. They're obviously necessary I don't understand. I don't understand that argument about the necessary party. So all those shit arguments were in his opposition. They weren't joined, so that's stupid. Should have checked to see if plaintiff had any works registered before alleging he had. No, he's trying to push the burden onto the defendant to rule out everything and to make his case for him. It was his obligation to allege that he had the registration. And their argument is that it should still be dismissed even despite the fact that he registered it, because at the time it wasn't registered. They can't raise new arguments in their reply. That was a shit argument. Unlawful. It's an unlawful. I hate it when soft sits use unlawful. It's an illegal and unlawful. Only soft sits use that kind of language. Let me rephrase that. Only soft sits abuse and misuse that language. The video that YouTube alleges was registered untimely was registered prior to supplemental complaint. I believe the action has to be filed before 17 USC 411. Oh, it's stupid bullshit again. No civil action or infringement. Oops, shit. No civil action or infringement of the copyright in any United States work shall be instituted. Yeah, so instituted. It doesn't relate back to it doesn't change anything. Your action does not become instituted at the filing of a supplemental complaint. You can file a lawsuit about anything. Technically correct. And that's generally speaking. The least you can get is $1. Or you may win. That's true. The least you can get is $1. That's not true. You can get less than $1. You could actually owe people money at the end of the day. That won't buy Chili a plain Starbucks. Okay. Chili watches my videos. Inapposite. Hi, Chili. You're a fucking idiot. Oh, Jesus. And again, see, like, he heard inapposite, but he didn't hear me saying that they only cited this district court case for the citations contained in the district court case. Jesus Christ. And he's just arguing this Cortez Ramos shit, and he doesn't understand it. He doesn't address any of the other cases. He just argues this one case. He's like a dog with a bone. Boy, he's not letting that one go. He doesn't understand it, and he shakes it around like he's going to kill it, but it's still just a bone. Jesus Christ. And then that whole moot argument is really stupid. It's so stupid. Finally, their argument is moot. Well, problem solved. Case closed. Let's go home, boys. Chili declared it moot. Chili claims that plaintiff admitted in its first amended complaint to having uploaded the registered video to YouTube. That is false and not alleged in the first amended complaint. The only videos that Chili has made allegations to being copyrighted. He has made no allegations as to which videos violate his copyright. He has only made allegations to which videos are copyrighted. And all of those links to those videos are YouTube. So yes, if the court grants a motion to dismiss, it should allow leave to amend. I think it will. Well, or I still think it'll dismiss without prejudice to allow plaintiff to refile in probably. I think the court will dismiss without prejudice to allow Chili to refile in the Northern District of California. That's what I think is going to happen. All right. Oh, shit. You weren't seeing any of that. I was going over all of this stupid nonsense. It's the same stuff that was in his motion for leave to file the surreply. All stupid, all bullshit. Let me close some tabs here and we'll move on. All right. Now, this is the next stupid thing. Oh, there's a lot of stupid in here. This is DeCastro versus LVPD. Where do we want to start? I think I've done the complaint. I think I did the amended complaint. Cock-a-doodle-doo, motherfucker. I talked about the motion to dismiss. It's an excellent motion to dismiss and very well written. And I'm sure that Chili's just going to file an amended complaint. Oh, interesting. Motion for preliminary injunction. Emergency motion for preliminary injunction to stay state proceedings. That's a problem. That's the younger abstention is going to slap him in the face. He was illegally arrested. He was cited for false statement. Defendants do not contest. I talked about this. The people were talking about it on my Discord channel, and they were saying that Chili was saying that plaintiffs don't contest, or the defendants don't contest his claims of excessive force in their motion for partial dismissal. They didn't file a 12B6 motion to dismiss those claims. That doesn't mean they're not contesting them. Once the motion to dismiss is decided, then the defendants will file their answer, and their answer is either going to admit or deny or explain why. Like I can't. Generally speaking, they're going to deny most of the allegations, and they're going to deny the allegations that he made about excessive force. But the way motions to dismiss work is that the court has to accept the allegations made in the complaint as true. It's different than a motion for summary judgment. So there's a distinction between those two. They're very similar, but they're not the same. A motion to dismiss, all that you're dealing with is the actual complaint itself and anything else that the court can take judicial notice of. So it's just the court has to accept everything in the complaint as true, and then based just on the complaint and things the court can take judicial notice of, then the court will either grant the motion to dismiss or deny it. A motion for summary judgment is a little bit different because the court will take all of the agreed upon facts as true. So usually it's after like discovery, things like that. The court will take all the agreed upon facts as true. And then the court will take all of the facts in favor of the non-moving party as true. So if the plaintiff is filing a motion for summary judgment, then the court will assume all the facts that are uncontested are true and or agreed upon are true, uncontested or agreed upon. And then the court will, if it's the plaintiff moving, the court will take all of the facts as alleged by the defendant as true and make its decision based on that. If it's the defendant who's filing the motion for summary judgment, it's the same process, except they'll assume that everything that the plaintiff has said is true, except for the uncontested and undisputed facts. I hope that makes sense. It's a little bit different. It's different enough that it gets a different name. It comes at a different stage of the pleadings. Generally, you're not alleging procedural, jurisdictional defects, things like that. You're just saying that that if this goes to trial, even if everything that the opposing party says is true, I'm going to win. So he's entirely wrong. I'm going to assume that the defendants are going to contest his claims of excessive force. It's just they haven't filed their answer yet. So there you go. Plaintiff expects excessive force to continue to be used against him if he's jailed waiting for trial. I don't know why he would expect that. In retaliation for plaintiff asserting his rights, First Amendment rights, and in violation of his First, Fourth, Eighth, and 14th Amendment rights. Defendants now claim additional offenses in their motion. Claim additional offenses. I believe what they were saying was that there was probable cause based on certain things, probable cause that he had committed this offense, that offense, or the other offense. I don't believe they're charging him with anything in their motion, because that wouldn't make sense at all. The charges would come in the criminal case, but you could have a cop could have probable cause to arrest you on something that you never get charged with. They even try to cite non-existent facts in plaintiff's complaint where no traffic stop is alleged. Well, Mark. All right, let's get the amended complaint. He was recording a police officer interaction. What was the police officer interaction? Well, it was a police interaction between a woman sitting in a car, and he was sitting in a car. Get off the table. Get. Jesus. Chickens. Get off the table. Let's see. Welcome to the chicken hour. All the chickens are around me right now. Well, some of them anyway. Let's do this. TRAFF. Nope. Well, I don't know. I don't know that it's such a huge deal. First of all, it was a traffic stop, and second of all, he does allege that there was a gal in a vehicle, a police interaction. He doesn't call it a traffic stop, but it was a police interaction. So I don't know that it's I don't know that that's anything fatal. Defendants raise in their motion only irrelevant cases where members of the public were not exercising their constitutionally protected rights and were in fact causing unsafe conditions or inserting themselves into investigations. Plaintiff was exercising his free speech. That's, calling it, trespassing while you're recording doesn't mean that you're not trespassing. And holding a camera and recording while you're doing it doesn't change it into the cops acting on you for trespassing and not acting on you for the recording. It's not the recording that's the problem. It's you trespassing, right? So it wasn't the fact that Chili was recording that's the issue. It's the fact that he was inserting himself into a police investigation. Plaintiff was exercising his free speech and recording the police and challenging. He's challenging. That's him inserting himself into the investigation. Defendants even make outrageous claims in their motion that discrimination based on the color of plaintiff's skin is not illegal discrimination under the 14th Amendment. I don't think so. I think they said there is no discrimination based on the color of his skin. I don't recall them saying that. I think they also said that it has to be some sort of a contractual issue, if I remember correctly. I don't think so, dude. Plaintiff shows like, I don't understand their argument, so it's an outrageous argument. What are you doing on the table? What are you doing on the table? Why are you up here? There's no food up here. Jesus. No. What are you doing? Get. Buck yourself. All right, sorry. Plaintiff only talked to the driver when the officer was in his vehicle and moved back to an area out of the way when the officer left his vehicle. He in no way participated in any obstructive behavior beyond the assertion of his rights to free speech. Who was that? It was News Now San Diego. Had a whole lawsuit. News Now San Diego versus Gore. I think it was like versus Gore or something like that. My face video has stopped moving. I don't know why you really want to see my face, but there you go. So it was News Now San Diego versus Gore. And he made similar accusations. He was kept out of police scenes. He was arrested for interfering by talking to people in the investigations. He alleged First Amendment violations when the police would move the crime scene tape back and force him further away. That was very well litigated in the Ninth Circuit, and I don't think that Chili's going to have much success in his particular arguments here. Just because you're recording doesn't mean the police can't prevent you from talking to defendants who are in custody and interfering. This court is proper forum for plaintiff's claims where the threat of a civil prosecution under state law that violates the First Amendment won't chill plaintiff's civil rights, especially as charges have not yet been brought. I think they have been brought. So the first hearing hasn't been held, but I mean, there is a criminal proceeding that's been instituted against him. I don't know what he's saying about it. It hasn't been brought yet. That's kind of silly. I haven't had my arraignment, so it hasn't been brought. I don't know. That's weird. Additionally, a malicious prosecution will further harm plaintiff and lead to supplemental claims. He's just run face first into Younger. Cock-a-doodle-doo. Plaintiff exercising his clearly established right to free speech is not obstruction or resisting. Yes, but is obstruction or resisting while you're talking, does that turn it into just a First Amendment issue? Or can they still arrest you for the obstruction or resisting? And yes, they can. It wasn't Chili's speech that they were having issues with. It was his pulling his arms away and not complying with their commands, like to put the phone down, etc., to move away from the scene, etc. Plaintiff has a clearly established First Amendment right to record police. Yes. Plaintiff has a right not to be harassed based on his viral videos criticizing the police. Viral videos criticizing the police. Let's check out Addison versus the city of Baker City. Oh, boy, I'm sure this is going to be great. Is this the right case? This is not the right case. This is F sub 3rd 1207. F sub 3rd 1207, which is not this. To the scholars. Case law, select courts. Oops, I'll show you over here so you can see what I'm doing. And this was a Ninth Circuit case, and so we're just going to select the whole Ninth Circuit because F it, that's why. We're going to be done there, and then we're going to look for Addison and Baker. Plus in there, plus Baker. So that is F sup. And we're going to custom range. And this was at 2018. Custom range at 2018 to 2018. So it says. Well, let's try this. Let's try it in quotes. Nothing. All right. Oops. Huh. Well, I don't know. I don't know what the hell he's quoting, and I'm not going to waste any more time on it because he still hasn't dealt with Younger. Federal Court has the authority to stay the action that Chile's plaintiffs to stay in action that chill apostrophe s possessive plaintiff civil rights, especially as charges have not yet been brought, and they have been brought, and so that's a problem. That's a problem. So we're going to look at Younger. Well, I'm sure they're going to go Younger. The judge didn't even wait for opposition. Oh, Jesus. He's a member of the press, forcibly arrested, blah, blah, blah. Apparently, he's being prosecuted for obstructing a police officer and resisting a police officer. He now moves for emergency preliminary injunction. He does not explain the nature of that first hearing, what he anticipates will happen at hearing, or how the hearing could impact his claims in this case. More importantly, federal courts cannot enjoin pending state criminal proceedings unless there are exceptional circumstances. Such circumstances do not exist here, so I deny DeCastro's motion. So that those circumstances would be like a habeas, or like if he's actually in custody, like habeas corpus proceeding, or like if he's being abused in that'd be a habeas. So yeah, I don't know of many other things besides a habeas. Principles of community equity dictate that federal courts should usually abstain from interfering with state court proceedings. That is the Younger abstention doctrine. Separate state governments, yada, yada, yada. 4-part test. Number 1, there has to be an ongoing state judicial proceeding. There is. Number 2, the proceeding implicates important state interests. Yes, not having people violate state laws is assumed to be an important state interest. 3, there is an adequate opportunity in state proceedings to raise constitutional challenges. Yes, he can allege violations of his constitutional rights in that state court proceeding. Literally, like a motion to suppress would be for a violation of his Fourth Amendment rights. A motion to dismiss or some sort of a demur, I don't know exactly how they have it, for First Amendment retaliation. I mean, you can raise all of these constitutional issues in the state court proceeding, and if there is a valid argument to be made, then I'm sure that Chile's attorney, apparently he has an attorney for this, Chile's attorney will raise those. The request for relief seeks to enjoin or has practical effect of enjoining the ongoing state proceedings. Yes, so if the court grants his motion for preliminary injunction, then yeah, it would enjoy it. Can't do that. Each of these factors is met here. He's seeking to enjoin ongoing state criminal proceeding, addressing whether he obstructed police activity and resisted arrest. These are important state interests. He hasn't explained why, and there's nothing to suggest that he cannot raise constitutional issues to his prosecution in that state case. He contends the timing of the criminal case will chill his rights, but he does not say how or why. Finally, he claims he would be subject to excessive force if he is jailed awaiting trial, but he gives no reason to suggest he will be jailed or why excessive force would be used against him if he is. I believe he's out on bail or bond. Now, here's a fun thing. Folks in my Discord were talking about how this particular attorney that Chile hired has a 100% success rate, advertised 100% success rate in either A, getting charges dismissed, or B, pleading down to no jail time. My understanding is that there has been a offer made by the prosecution, and the attorney, my understanding, third hand, is that the attorney said that Chile won't accept it, but he's going to take it to Chile because obviously he has to present it to Chile. So I'm sure this attorney is not looking forward to having Chile press him to take this all the way to trial and blemish the 100% success rate. All right. And then we have this nonsense, a motion by some guy for joinder. I'm sure this will be amazing. So somebody by the name of Jason A. Jensen, FRCP20 is joinder. He wants to join the motion to stay. He wants to join the motion to stay. He doesn't want to join the case. He wants to join the motion to stay. Chef's kiss. Jensen furthers said motion with a petition for extraordinary writ of mandamus. So let's get this straight. The day after the judge denies the motion for preliminary injunction, this dipshit tries to join the motion for preliminary injunction. Wait, plaintiff's motion to stay. I think preliminary injunction. Present in the defense of Mr. DeCastro's amended complaint, the state of Nevada and its political subdivisions have orchestrated a policy with express intent to create recording and talking to a roadside traffic stop detainee criminal under the legal theory of obstruction of an officer's duties. He's charged with these crimes. He cannot mount a defense based on the rights of traffic stop detainees, Miranda rights, and principles of Berkemer versus McCarthy. What in the actual fuck is this guy on about? Roadside questioning of a motorist detained pursuant to a routine traffic stop does not constitute custodial interrogation, although it curtails the freedom of action, imposes some pressure. Excuse me, sir. You seem to have sprung a leak. Are you done? Okay. This is about Miranda. This has nothing to do with having conversations with people who are detained. So I don't know what he's on about. Mr. Jensen cannot motion to intervene in the criminal matter at state court. Obviously, because you're a fucking idiot. This is the exact mechanism the state is using the denial of two class persons. There's no class action going on. There's no class action. Why are we talking about class persons? What in the... Or any person charged by obstruction by exercising the right granted to the public in conjunction with a traffic stop detainee's Miranda rights. So this guy is trying to make an argument. Jensen, I don't know if this guy's a troll or not, but he's trying to make an argument that your Miranda rights are not a right to remain silent, a right to have an attorney present, blah, blah, blah. Your Miranda rights are the right to interfere in a traffic stop or to have someone interfere in your traffic stop and talk to you. I've never heard of that particular Miranda right. So DeCastro's attorney asked to skip the status conference and go straight to scheduling a trial date instead. Right. So if he's not waiving time, then yeah, he wants to get a trial date scheduled. Yeah, that's not unusual if you're not waiving time. The Shirley probably said no waiving time. Waiving time is sometimes a so you have the right to a speedy trial, and normally well, I shouldn't say normally. My experience in going to court on arraignments and things like that is more often than not, the attorneys that I've been around and myself in these particular cases will waive speedy. They'll waive the right to a speedy trial. They'll waive time. So that allows the defense more time to prepare their case. The bad side is it also allows the prosecution more time to prepare theirs. It can be an effective strategy, to not waive time, to not give the prosecution more opportunity to find witnesses, etc. So I can understand why DeCastro may not have waived time, and that would basically require getting a date set. He said he knew DeCastro wouldn't accept the state's offer, so why waste time? I actually agreed with him, but the judge didn't. Oh, well, so he doesn't have the attorney does not have the authority to reject an offer until the client rejects the offer. You have to communicate the offer to the client. The accepting or rejecting it is entirely up to the client, and they're not going to offer a blanket anything. All right, so that's Jensen. I'm going to assume the court's going to deny it. Oh, we got a motion for reconsideration. Nice. So Chile wants an emergency motion for reconsideration. This was filed on 6/13. Wasn't his hearing on 6/12 or something like that? The time of the criminal action, 8 a.m. on the 13th. He files this on the 13th. Phone doesn't usually work. Sorry. Holy Jesus, phone doesn't usually work. Sorry. You know what, court? My phone doesn't usually work. The problem, I think I know why he did this. He has to give a phone number that's actually going to ring to him, and he doesn't want you and me to see that phone number. The emergency motion is made because of the timing. Yeah, so basically the day of the arraignment, plaintiff had expected his internal affairs complaint to have been completed, but the LVMPD's own delays have led us here. They've led us here. What the fuck does that even mean? Like, just because you make an internal, like, in a lot of ways, it's really stupid to expect the police to investigate themselves and find that they've done something wrong. Now, they may find that they've done something wrong, and if it's something particularly egregious, they probably will, because having officers do things that violate policy, generally speaking, will expose. The policies are designed to prevent officers from doing things that will expose the departments to liability. So if an officer is violating policy, especially if it's egregious, something that would expose the department to dollary dues, then they're more likely to act on their internal affairs complaint. Because if they don't, then there is the potential for a Manel claim. Remember, Manel doesn't mean that there's a policy that doesn't necessarily mean that there's a policy in place that allows for the officer to do that. But if they are not enforcing policies preventing officers from doing things like violating your rights, then a Manel claim is appropriate, and it might expose the department to liability. So there is some impetus on the police to do internal affairs. But if it's a wobbler, I wouldn't expect the internal affairs to do much, because if they do something and they say, yeah, our officer was wrong, they're going to expose that officer to liability. If it's a wobbler, and it also might expose them to liability because the officer might sue them, right? But if it's a wobbler, I would expect them not to do anything. Or if it's something that they can't prove, I wouldn't expect them to do anything. So the motion for reconsideration is made under FRCP 59E and 60A1, requesting consideration and identifying error. He identified error in the court's order. So the court erred. He said, "Court, you don't understand the law, court. Younger doesn't apply to this situation." I already see he's quoting. He's looking younger. The citation did not say what the first hearing is, and so plaintiff can only guess what normally a first hearing is. Normally, a first hearing is the arraignment. That's usually, in my experience, where criminal cases start. They file a complaint. The next step is the arraignment. The arraignment is basically, instead of you filing an answer, the arraignment is basically you going in front of the judge and saying that you agree with the allegations the state has made, or you deny the allegations the state has made. Just like with an answer to a criminal or to a civil complaint, if you agree with everything that the plaintiff said, then summary judgment, bada boom, bada bing. That would be your guilty plea, and then you go to sentencing. Or if you disagree with it, well, then the state has to prove its case. Just like if you disagree with it, if you file a denial in a civil case, then the plaintiff has to prove everything. The arraignment is essentially the answer. It's the criminal version of a civil answer. So obviously it's an arraignment, but I guess you could only guess. I'm sure that they probably said something along the lines of your arraignment is set for this date at this time. Since they're misdemeanor offenses, which may not grant a probable cause hearing or a grand jury. So in California, there's two ways. I'm not sure. I know so grand jury is normally where the prosecution takes this case to a grand jury, and the grand jury returns a finding of probable cause. They'll issue a true bill. Now, I'm not sure if I know in California there's a preliminary hearing, a probable cause hearing, which is basically like a mini trial, where the state has to prove. It's a super low bar. I mean, probable cause is almost impossible not to prove, but it's basically a mini trial. They call witnesses, they present evidence. I believe the rules of evidence are slightly relaxed, but yeah, but that comes after the arraignment. The arraignment comes first. At the arraignment, at least in California, the preliminary hearing, the probable cause hearing, is I think 10 days. I think it's set for 10 days after it. But of course, the parties can agree to a later one if they want to. So yeah, but those are for felonies. I'm not sure. I don't practice criminal law in Nevada, so I don't know exactly. But they probably have something fairly similar. I would guess they have to have some sort of a way for the court to determine whether or not there is actual probable cause for the hearing to proceed, for the trial to proceed. Another fun thing at a California probable cause hearing, preliminary hearing, is that's the first spot where you can motion to have wobblers, like something could be charged as a misdemeanor or a felony. If the DA has decided to charge it as a felony, then that's the first opportunity you have to ask the court to have it charged as a misdemeanor instead. So, yeah. An arraignment resulting in charges will result in defendants making a motion to stay these proceedings as they have promised under the Younger Doctrine. The arraignment is where the charges are read. I don't understand. The arraignment doesn't result in charges. The arraignment is where charges are read. I have to pee, so I'm going to go pee, and you don't get to come with me. But I'll be right back. I've had one and about 3/4, 300 milligram rock stars, 300 milligrams of caffeine rock stars. So, woo! So we were talking about arraignments don't result in charges. The charges are read in an arraignment. The court cited Younger, which clearly states a federal court should only enjoin a pending state criminal proceeding. Yeah, in the initial motion that Chile filed for preliminary injunction, he gave a case number. There is a pending criminal proceeding. If there's a case number, that means that a criminal complaint has been filed. You don't get the case number until the criminal complaint is filed. One of the things that is very frustrating is every criminal defendant that I have had the pleasure of doing work on, someone just pulled up to the gate. Every single one of them has come in prior to the complaint being filed. And so you can't look up on the court's website when the hearing dates are and things like that. And it's not until the complaint has been filed that you can see that's when you get the case numbers, when the DA files the complaint. So once the complaint is filed, there are definitely pending state criminal proceedings. I mean, there's definitely pending state criminal proceedings. In fact, I would posit to you that as soon as you have that citation, the ticket, the misdemeanor ticket, normally they give you some sort of a citation or something saying that you've been arrested for this charge, then I would suggest to you at that point the state criminal proceedings have started. I would argue that because your rights to an attorney have attached. All sorts of other fun things have attached at that point. So, but definitely by the time there is a complaint filed, definitely at that point there is a pending state criminal proceeding. He says, however, the criminal action in the instant action is not pending. The U.S. Supreme Court has held that I don't know why he says that. The U.S. Supreme Court has held that a preliminary injunction is not held to the strict Younger standard if charges have not yet been filed. They have been filed. There is a criminal complaint in place. So I don't understand what he means by that. Additionally, the U.S. Supreme Court has said that one is entitled to a preliminary injunction when the question is a matter of civil rights, as it is in the instant action. In Younger, the court recognized principles of judicial economy as well as proper federal-state relations preclude federal courts from exercising equitable jurisdiction to enjoin ongoing state prosecutions. However, when a genuine threat of prosecution exists, a litigant is entitled to resort to a federal forum to seek redress for an alleged deprivation of federal rights. Well, let's look at that. Let's look at Woolley versus Maynard. Let's look at it. Let's look at it. Googly. Woolley versus Maynard. Oh, this case. I remember this case. So there were 3, I believe. He was found guilty 3 times. And there may be future ones coming. So it's already something that has happened. There have been past convictions. So, yeah, that is inapposite. Sorry, kid, inapposite. In fact, I went through each of these on my Discord and stated why they were inapposite. So, like, one of them, somebody purchased the corporation after charges were filed against the previous owners. They purchased the corporation after the charges were filed against that corporation. So anyway, they're all inapposite. All of these basically are situations where it's a corporate issue or where charges have already been filed in some form or have not been filed against the defendant, respondent, appellant, plaintiff. There we go. Charges have not been filed against the plaintiff in these, or charges have been filed, but have been resolved. So they were all, I was able to distinguish all of them. Although death, I could die if I go to jail. They're going to put their fists up my butt. Although death in a corrupt jail would make it impossible to raise constitutional challenges in a state case, plaintiff is only required to raise threat of prosecution, chilling his First Amendment rights, which would occur if plaintiff is in jail, which plaintiff did raise. Yeah, but it's not threat of prosecution. It's actual prosecution. The complaint has been filed. This court has also said that plaintiff is given no reason to suggest he will be jailed. In the motion page 1, line 7 to 8, the offenses are listed, which are misdemeanors, which carry maximum jail time of 6 months. Additionally, there's no guarantee of bail before trial. Okay. So now that those charges are not pending, the day of the hearing for the where he has to plead his arraignment, he files the emergency motion to try to suggest that charges aren't pending. You can't make this shit up. Whoop, shit. You guys aren't seeing any of this. Sorry. Yeah, it was death in a corrupt jail. Death in a corrupt jail would make it impossible. Yeah, fucking stupid. All right. So that was his emergency motion. Let's see. Motion for leave to file suggestions. I want to file suggestions, Your Honor. I already fixed it, Jose. No way, Jose. I already fixed it. I fixed it. Merb, change the screen. I did. You guys suck. Change your screen. I did. Look, I see what we're on now. I'm looking at it, and we're on Jensen's motion for leave to file suggestions. Motion for leave to file suggestions. What the fuck does that even mean? File suggestions in opposition to their motion for partial dismissal. He's going to file suggestions. And that's it. Can I file suggestions? Oh, Jesus. Whoever this Jensen is, you know, it's a hard call to know if someone is really, really stupid or if they're a really good troll. I have to assume that this guy is just trolling the shit out of everybody, because that is hilarious. Motion for leave to file suggestions. Oh Christ. That's fucking amazing. So his motion for joinder, is denied. Intervener plaintiff, he seeks a stay. His joinder fails for a number of reasons. First, the motion seeks federal judicial intervention in a pending state criminal proceeding, so we're back to younger. Second, a non-party to the dispute filed in this court cannot intervene in this case unless he establishes an interest in the events that are the subject matter of the underlying action. So, like, if he was a party to the arrest of Chile, where Chile was obstructing and resisting, he fails to establish any basis to intervene. Further, FRCP 20 provide he has no intervention rights under the circumstances presented. Third, and finally, a writ of mandamus is an extraordinary remedy limited to extraordinary cases. When evaluating mandamus petitions, courts are guided by what is known as the Bauman factors, which include 1, whether the petitioner has no other means, such as direct appeal, to obtain the desired relief; 2, whether the petitioner will be damaged or prejudiced in any way not correctable on appeal; 3, whether the district court's order is clearly erroneous as a matter of law; and 4, whether the district court's order is an oft-repeated error or manifests a persistent disregard of the federal rules; and 5, whether the district court's order raises new and important problems or issues of first impression. Mr. Jensen fails to address any of these factors in his filing. Further, what is decipherable in Mr. Jensen's motion presents nothing warranting the court's intervention in a state court proceeding apparently underlying Mr. Jensen's filing. That is a burn. Further, what is decipherable, meaning what you said doesn't make any goddamn sense, and it's hard for me to figure out what the fuck you're talking about. So the magistrate judge denied the shit out of that, which is awesome. Oh, I love this Jensen guy. Non-party, this is denying his motion for leave to file opposition to motion to dismiss. He didn't ask for leave to file an opposition. He asked for leave to file suggestions. Oh my God. Non-party Jason Jensen has filed documents in this case, including a motion for leave to file in opposition to defendant's motion to dismiss. Jensen has also submitted other documents to the clerk of court in this matter. As Magistrate Judge Yucha previously explained to Jensen, he is not a party or intervener in this case. Jensen does not demonstrate a legal basis for him to bring issues related to this dispute to the court's attention. Unauthorized filings waste resources, delay the court's ability to address meritorious matters, and abuse the court system. Jensen is not a party, and there's no identifiable basis for his joinder or intervention. I therefore order that Jason Jensen's motion for leave to file in opposition to the defendant's motion to dismiss is denied. I further order that Jason Jensen must cease filing documents in this case. Jensen may only file a properly supported motion to allow his joinder or intervention, and he may file no other documents in this case unless that motion is granted. I further order the clerk of the court need not file the documents that Jensen has submitted to date and need not file any other document Jensen submits in this case except a motion to join or intervene. Oh, delightful. Delightful. I think there's something else I wanted to discuss. We're going to go to the YubTubs. YouTube. Hey, look, I'm live streaming right now. And what was I going to talk about? I was going to talk about a thing. Let me look to see if I remember the thing. I think it was a Freeman thing. Oh, that's right. I want to talk about, there we go. Freeman has made a big deal about his lawsuit against the 7th Judicial Circuit. So we're going to see if that's on Court Listener.com, and we want Springer, and we want New Mexico. Boom. All right, let's see if we got it. Oop, share this tab instead. Oh, all of you guys are just terrible, terrible people. Terrible, terrible people doing terrible, terrible things. I hate you all. So there is a extension. There is an extension called Recap. And I don't want. Hold on a second. Hold on a second. I thought I saw them. I saw them. I thought I saw them. Let's see. Do I have? Did someone give them to me? Since people stopped posting this shit, I have to figure out how to find it. I thought I saw it. My many thanks to Senor Frog, who is a gentleman and a scholar. I don't care what you guys say about him. He's all right, even if he does jam all of his videos full of crappy advertisements. He's an English pensioner. He needs to be able to supplement his income. All right, so we want pensioner. I'm going to show you. Exhibit 2. I'm going to show you. Exhibit 3. We're going to show you. Exhibit 4. We're going to show you. Exhibit 5. We're going to show you. Because it's a pretty interesting case. I found it to be interesting, and you may or may not agree with me. All right. So this is James Freeman versus the 7th Judicial District Court. So he's seeking declaratory and injunctive relief. So he wouldn't be able to sue for damages. I think he would be prevented from suing for damages. But declaratory and injunctive relief, I think he is in good standing for. Well, at least he has a colorable argument for it. Let me see if I can't make this bigger. That's what she said. Waka waka. All right, so he seeks to get a temporary restraining order, preliminary injunction, and permanent injunction relief pursuant to FRCP 65, and for declaratory relief against the individually named defendants acting in their individual capacities under color of law for damages against. He's asking for damages. He's asking for damages. I don't think he's going to be able to get damages. Judicial immunity, I think, is going to prevent him from getting damages. At least against Mercedes Murphy as a judge. The other people aren't judges, so I don't know if he's going to be able to get it against them. But Frog speaks Spanish? I don't know. Ask Frog. All right. Introduction, blah, blah, blah. Parties and jurisdiction. So clerks. So there's 2 judges. So you got Mercedes Murphy as a judge. Shannon Murdoch Poff is a judge. But then you got Jason Jones. So I don't think the judges, I don't think you can sue them for damages. The court executive officer and the clerk, maybe. But if they're acting under the judge's orders, I'm not sure entirely what liability they would have. And additionally, you'd have to James might have to have a hard time showing damages. because you have to actually prove damages. He might only be entitled to nominal damages, i.e., like $1, unless you could actually show a dollar amount that he was injured by. So, general allegations. He's an independent investigative journalist who produces content intended to expose to the general public cases of government fraud, waste, and abuse. Now, whatever you may think of him, that's what he thinks of himself as. He thinks that he is exposing government fraud, waste, and abuse. I disagree with him on quite a number of issues. I agree, generally speaking, we have too much government, but I don't think he's barking up the wrong tree. And I don't think one of the things you'll notice that he doesn't actually ask for the right to film in a courtroom. He makes a big deal about how he's fighting for your right to film in a courtroom, but nothing that he's asking for here is declaratory or injunctive relief allowing him to film in the courtroom. I want to be very clear about that. So this is about actions that the courts have taken against him, that he has at least a plausible claim for relief. In the first quarter of 2023, plaintiff engaged in investigative journalism at the Moriarty Magistrate Courthouse. Your mileage may vary there. You could say that he was being disruptive or what have you. You don't have the right to disrupt a court just because he is investigating things in the court. And once again, I always harken back to, number one, the Supreme Court only allows certain people in. If the Supreme Court can only allow certain people in to the proceeding, then what makes you believe that any other court can't limit the number of people in their courtroom? There's nothing in the Constitution that grants the Supreme Court any powers beyond interpreting the Constitution. So there's nothing in the Constitution that says that the Supreme Court has the extra ability to prevent filming in it. There's nothing in the Constitution that says the Supreme Court has an extra ability to exclude people from its courtrooms. So the Supreme Court has interpreted the Constitution, and you're going to say, well, there's no ruling on this. But look at what the Supreme Court does. The Supreme Court restricts filming and audio recording even in its court. The Supreme Court restricts who can go into its court, which is by implication saying that the Supreme Court thinks it's constitutionally valid for courts to restrict filming and audio recording, and for courts to restrict who can get in to see the trial. So just remember that. I mean, if he did try to bring a lawsuit to enjoin the court from prohibiting audio, video recording inside the courtrooms or courthouse, then he would have a massive uphill struggle on that to convince the court that the court doesn't have that power. So he doesn't do it here. So this is not about that. I just want to make that very clear. While most of plaintiff's investigative journalism focuses on police misconduct and abuse of power, plaintiff also exercises his First Amendment rights to produce content related to other government officials besides police officers, including but not limited to local elected officials and government employees and judicial officers and administrators. Plaintiff displays the content described in paragraphs 8 through 10 above on a YouTube channel he operates called James Freeman. Approximately 444,000 people around the world subscribe to and enjoy his YouTube channel called James Freeman. I don't often watch his content because I find his analysis is very problematic. And the biased manner in which he sets up, he's not fair at all in how he sets up these things, and his understanding of the law is suspect at best. So I rarely enjoy his videos. Sometimes he's got a real winner. Sometimes he's got a real winner of an argument, like where the cop did something that's blatantly wrong. You're like, yeah, dude, I agree with you on that one. But generally speaking, it's margin call stuff where it's mostly his bias being displayed and not something necessarily that the cop did. In February of 2023, plaintiff posted one or more videos featuring interactions with a domestic relations hearing officer in the 7th Judicial District Court for Torrance County, as well as with court personnel and other employees of the Torrance County Sheriff's Office. In those videos, I want to remind you that he was calling on the sheriff to not enforce orders issued by the judge, that he was saying that he would not abide by those orders, where he was going in yelling at, there's videos of him that like yelling red-faced at the clerks, calling them cowards and things like that. I mean, there's video evidence of this, so just be aware of that. I mean, he was just investigative journalism, but I remember him red-faced yelling, calling him cowards, telling him to come outside and things like that. On or about March 1st, 2023, two officers with the New Mexico State Police hand-delivered to plaintiff an administrative order entered on March 28th, so after February, a month after the February posting, signed by the Honorable Mercedes Murphy, Chief Judge of the 7th Judicial District. See exhibit attached hereto and incorporated by reference as Exhibit 1. We will actually go to that now. Share this tab instead. So I could not find this case. Let's see if we can't go to what is it? The 7th Judicial District Court. 7th Judicial District Court online case search. And I found it before. I found a search before. Find a case. Here we go. Oh, you can't see this one. Find a case. All right. I accept. I am not a robot. I am not a robot. And Springer James. We'll do that. That could be him, but that was from 2018. Why do you got to get on the? Why you got to get on the table, stupid chicken? Stupid chicken. So there's only 9. So you can see the search feature works. His middle name is Alan, so this is the only one that could be him, and that was a misdemeanor. But you can also look it up by case number. There you go, case number search. And that one was move you over to here so I can see it while I'm typing. And we're going to go back to this, and it is case B, and it is 722. And there's others that have MS 2023 00001. No results found. All right, and we're going to move this back to here. We're going to go back to share this instead. So you can confirm that is the case number I entered. There's no dash. You don't put a dash in. So there you go. You don't like my loud cock-hooded friend? That's not what you said last night. So there's an administrative order. The matter having come to the attention of the court, and the court being fully advised that in the interest of the safety and security of judges, special commissioners, hearing officers, and other court personnel, it is hereby ordered, adjudged, and decreed that James Springer, Freeman, 6 foot, 170 pounds, date of birth, yada yada, is hereby banned from entering the Torrance County District Court at Neil Mertz Judicial Complex, 903 North 5th Street, Estacia, New Mexico, unless appearing for a hearing or having specific court business. Court business, not business that Freeman has in court. In which case, the individual shall be escorted and accompanied by the Torrance County Sheriff's Office while in the building. It is further ordered, adjudged, and decreed that James Allen Springer, upon entering the Neil Mertz Judicial Complex, shall enter the TCSO and identify himself to the TCSO as being an obstinate visitor. Upon entering into the building, alerting law enforcement, they must be escorted and accompanied pursuant to this order effective March 1, 2023. Now, what this looks like to me is this looks like the court has basically done a secret hearing where they've tried Springer and they've rendered a judgment against him. It's not like they trespassed him. Well, it's kind of like they trespassed him, but they haven't. It's not a trespass. This is a court order. It's a court order with a case number filed. It's in the matter of James Allen Springer, aka James Freeman. Like, I am flabbergasted that the court did this. I don't know what the remedy for this is, but one would assume that in the matter of James Allen Springer, that James Allen Springer would be a necessary party, that he would be served with something, not the order at the end of it, but he would be served with a complaint so that he would have notice and an opportunity to be heard. As I indicated last night, I love your loud cock. That's my boy. That's my boy. That's my boy. So this is, I you know, I'm harshly critical of Freeman, but this appears to be an order against Freeman, eliminating some of his rights and privileges without notice and opportunity to be heard. So, yeah, pursuant to the administrative order attached here to as Exhibit 1, he's banned from entering that particular complex unless appearing for a hearing or having specific court business. In the event he does appear, it requires him to be escorted by the Torrance County Sheriff's Office. It further orders the judges and decrees that upon entering that complex, he has to go in and identify himself as being an obstinate visitor. He has to take actions. There's an order against him requiring him to take actions that he didn't have an opportunity to object to oppose. Like, if this was just, you can't come here, if this is just a trespass order, that would be one thing. This isn't that. He has to go in there and be like, I am ordered by the court. I can be held in contempt if I don't do this, to tell you that I'm an obstinate visitor. Felipe's review of Merb's beard will follow. Likely not. Why not, Felipe? You love to talk about my beard. Jensen was on Welsh News Network. Apparently he's known as the Motions Man. He's a nutbag sovereign citizen. He writes shitty motions, so I don't know why anyone would call him the Motions Man unless they're talking about like bowel movements. All right, on or about March 1st, 2023, at the same time, officers of the New Mexico State Police hand-delivered to plaintiff the administrative order attached to his Exhibit 1. Those same officers also hand-delivered to plaintiff a letter from Jason Jones, Executive Court Officer of the 7th Judicial District. See exhibit attached here to and incorporated here as Exhibit. Oh, shit. I wasn't sharing the right screen. This was the stuff that I was reading. So there you go. Now we're on to Jason Jones and Exhibit 2. Share this tab instead. As the CEO of the 7th Judicial District, it has been brought to my attention that court staff are being harassed on your behalf and has impacted court resources. The court has issued an administrative order on March 1, 2023, that if you are required to be in court or have official court business, you will check in with the Torrance County Sheriff's Office to be escorted and accompanied pursuant to the administrative order. I don't know why this would expose Jason Jones to any liability. All he's saying is that, hey, there's a court order here. I don't know that he's liable for this particular one. I mean, unless some pleadings come out showing that it was him who prepared and filed the complaint or something like that in the case, in the matter of James Allen Springer, and I haven't seen anything to that effect. All right, now we're going to go back to this tab. The letter attached here to describe the contents of the administrative order, but provides no notice of wrongdoing plaintiff is alleged to have committed, such that he could be legally deprived of his rights under the New Mexico Bill of Rights. He's just saying that there's a court order. That's all that the CEO of the court said. So I don't see any liability on his part. On March 23rd, 2023, the chief judge of the 7th Judicial District Court entered an amended administrative order, amending the administrative order attached here to as Exhibit 3 to ban plaintiff on entering various other properties of the 7th Judicial District. See exhibit attached here to incorporated by reference as Exhibit 3. So now Exhibit 3, that's this tab. Now you look, there's 4 cases. 1, 2, 3, 4. 4 cases. And I couldn't find any of those. You can just take me at my word. I looked them up. None of them populated. You can check it out on your own. It's here on the screen. Let me make it nice and that's as big as I can make it for you. It's as big as I can make it for you. So none of those are active cases. So, or at least they don't come up on the search. Again, it's styled in the matter of James Allen Springer. Apparently, he has 4 cases against him, and it's going to be up to a Veer. Excuse me. My German is as bad as my English, or worse. So it's the same thing. It's the exact same thing. The only difference is they added all these extra courthouses. So now he has to go into all these. If he goes in any of the courthouses, there's no evidence of Merb, get a job, you damn liar. Merb spreading more BS. Well, bye-bye. And bye-bye. All right. So again, we don't have any indication that Freeman was ever given notice and an opportunity to be heard. And according to Freeman's complaint, he wasn't. All the case numbers end in 2023-001. I think the operative part is the D-722 MS. I don't know what MS stands for. It almost looks like a misdemeanor. Why are you up on my goddamn table again? Why are you up on my table? You don't belong up here. This is a chicken-free zone. Stupid chickens. So I think it's like D722, D721, D725, and D728 are the operable ones. All right. So, and then Jason Jones, an exhibit. Jason Jones sent another letter. That is this one here. Same basic thing. The court amended it, yada, yada. Again, I don't see that this exposes Jason Jones to any liability, but I could be wrong. All right. Plaintiff was never given notice and opportunity to be heard on the matter of the deprivation of his rights under the First Amendment, 14th Amendment, or Article 2 of the New Mexico Constitution that resulted from the actions of defendants as described in paragraphs 15 through 23. On May 18th, he attempted to exercise his rights as guaranteed under the United States Constitution and the Mexico Constitution by attending a public hearing as a member of the press report on the case in a criminal matter before the Honorable Mercedes Murphy by way of a video conferencing platform. So he goes to a Zoom hearing, right? So he's not in the court. He's not in violation at all of any of the court orders. After dialing into the public hearing via the video conferencing platform, Judge Murphy summarily ejected plaintiff from the video conferencing platform and from the public hearing without providing plaintiff notice and opportunity to be heard on the matter of whether he could attend the public hearing. On May 24th, Judge Shannon Murdoch Poff issued an order, Exhibit 5 attached here to, excluding plaintiff from a hearing in civil matter. This is a DV that plaintiff planned to attend as a member of the press and public. Order excluding presence. And now the matter having come before the court sua sponte, the court of its own volition. Sua sponte means that the court just decided to do this all on its own without any prompting. The court having received an email from Mr. James Springer, aka James Freeman, that he intended to attend the above captioned matter with the intent to record the proceedings, and Mr. Springer having previously been banned from being in the courthouse without legitimate relevant business, it is hereby ordered that he remains banned from the Torrance County Courthouse by prior order and is specifically banned from attending the above captioned matter on May 24th, 2023, as per Chief Judge Murphy. Now, this one is a little less iffy because he said, I'm going to go there and I'm going to record the proceedings in a DV. Now, I don't know why the court would allow that. And the court could have said, no, you can't come here and do that. But to exclude him entirely, I think the portion of this order that excludes him from the hearing based on the previous order by Judge Murphy, I think should be set aside. That's my best guess. On multiple dates, Susan Rossignol has either refused service in the clerk's office or has required police presence to harass and intimidate plaintiff when he entered the Estancia District Courthouse for the purpose of conducting court business associated with making records requests. This culminated in an outright refusal to accept plaintiff's requests for service on June 8, 2023, and Ms. Rossignol requiring the Torrance County Sheriff's Department Deputy Wrong to chase plaintiff from the building, which he did. Now, your right to request records might be subject to you not being an asshat in making those requests. If he was, I swear to God, if he was being a jerk to her, then that there might be something there. But again, I don't know that he has some sort of a constitutional right that she violated. So I don't know where he's going to get the damages on her personally. Violation of freedom of the press, 1983. First Amendment guarantees your right to freedom of freedom of expression, freedom of speech, and right to petition the government for redress. Prohibits infringement of the freedom of press to report on affairs of the government by the government. There are several cases on this. I'm not going to look any of them up, but basically the court can, in the interest of justice, restrict the access of the public to various courts. So the First Amendment is subordinated to your right to a fair trial in the court. Well, thanks for letting me know. I don't know and don't care who you are. So peace out. As the government actors individually acting under color of law, Judge Murphy and Judge Murdoch Poff engage in viewpoint discrimination by banning and excluding plaintiff from public places and hearings, prohibiting him attending and reporting on public matters. That is not what the order says. The order said that basically he was harassing and threatening people. So that's going to become a matter of contention, I'm sure. And now he says that Judge Murphy and Judge Murdoch Poff do not enjoy judicial immunity here for their administrative orders. A judge is not immune from liability for non-judicial actions, i.e. actions not taken in the judge's judicial capacity. This important legal principle was recently applied to bail in the context of suing members of the judiciary in Schultz v. State, a district of Northern District of Alabama district court opinion, unpublished, wherein the district court there applied the guidance from the 11th Circuit, which is I believe, a different circuit. I think, isn't New Mexico like 5th Circuit? New Mexico, 5th Circuit? No. What federal circuit is New Mexico in? 10th Circuit. Oh, they're the same as Oklahoma, not Texas. Makes sense. Okay. So I don't know why you'd be applying 11th Circuit decisions, 11th Circuit district court cases that apply guidance from the 11th Circuit. Why do you have to get up on this table? I swear to God. So another 11th Circuit case is what they're citing. The court should consider the nature of function. The precise act complained of is a normal judicial function. The events involved occurred in the judge's chambers. The controversy centered around the case and pending before the judge, and the confrontation arose directly and immediately out of a visit to the judge in his official capacity. None of the conduct complained fits within the mireless definition of judicial conduct warranting absolute judicial immunity. I'm going to disagree ever so slightly, because you'll notice that it is an order in the matter of James Allen Springer with the case number. Inigo agrees that it does appear. I'm gonna say that they probably do have judicial immunity. The number one rule is when someone to someone's channel, don't respond. Felipe, you quoted the second rule. I don't know. All right. Substantive due process. Plaintiffs have protected liberty, interests, and free speech, free press, and petitioning for redress. So this would be there is a right in the Constitution for public trials. So defendants in criminal cases have a right to a public trial. And so there is a corresponding right of the public to attend a criminal trial. Again, subordinated to the interests of justice, because the number one point of a court is to theoretically get justice. So he does have a right under freedom of the press to attend court proceedings, but again, that is subordinated to the right to a fair trial. Substantive due process prevents government from engaging in conduct that shocks the conscience or that interferes with fundamental liberty without narrowly tailoring such interference to achieve a compelling government interest, which must withstand strict scrutiny. Defendant's actions constitute deprivations of those rights contrary to substantive due process. It seeks declaratory and injunctive relief to halt these deprivations of due process. I have a sense, my gut instinct of where this is going is that the federal court will probably issue injunctive relief, eliminating the existing court orders on Freeman. I don't think the federal court will issue an order preventing the 7th Judicial District Court from ever banning Freeman. But I do see that he does have a right to substantive and procedural due process. Procedural due process, here we go. Forbids the state from depriving anybody's life, liberty, or property without due process of law. No due process protections have been afforded to plaintiff. Agreed, 100%. All fundamental rights comprised within the term liberty, but including but not limited to the right to be free from bodily restraint, right to contact and engage in common occupations of life, right to acquire useful knowledge, worship God according to the dictates of one's own conscience, and generally enjoy the privileges long associated with the rights of free people are guaranteed substantive due process under the 14th Amendment. The most shocking thing is that there was a duty imposed on Freeman to act. I mean, if it was just something where like you can't do this, that would be different. But there was a requirement that Freeman act, that he go out and actually proactively say and do things. Crazy. Violation of the New Mexico Constitution, which I'm sure is going to be, generally speaking, free speech in constitutions are interpreted very similarly to or the same as free speech in the U.S. Constitution. Jury demand. So the interesting thing is there's a jury demand here. Jury demands, juries can't determine things, equitable relief. Juries can only figure out damages. And I don't remember, California is the opposite of the federal courts. I think in California, they figure out, in California, I think they do the jury damages first, and then the judge will do the equitable issues, the injunctive relief and things like that. And in federal, I think it's the opposite. I think the judge determines the equitable issues first, and then it goes to the jury on the damages. So the jury will not be deciding the declaratory and injunctive relief. The jury won't be doing the temporary restraining order, the preliminary injunction, or the permanent injunction. They will just be deciding issues of damages. All right. So setting the fact aside that the orders were issued without Freeman's presence, how often do you have to disrupt a court to get such an order against you? Well, theoretically, you could get trespassed, theoretically, depending on state law. You could probably get trespassed after one incident. You could probably get contempt of court, like direct contempt, if you disrupt the court in the court's presence. Only one, but the issue here isn't that the court issued the order; it's how the court issued the order. Like I remember Freeman saying there was something about a OSC rank contempt, in order to show cause about contempt, that he'd been served. So if the court had brought him in on that, he would have an opportunity to be heard. So, but the court didn't do that. The court, I guess, vacated that particular order to show cause, and so he never got his day in court. It's not the order so much as how they got the order. I think is the big issue. The big issue is the procedural due process. They did it without notice and opportunity to be heard. Can you be trespassed effectively from a courthouse for being disruptive? Yes. As long as you have those limitations on being allowed to go in for your hearings, on being allowed to go in on official court business, maybe with some restrictions on having to check in with the sheriff. But having a court
issue that kind of order without notice and opportunity to be heard is, I think, just a terrible idea. Judges have pretty broad discretion in their courtrooms, but these orders seem to step outside the boundaries a bit, possibly. Well, no, the judges can make orders about what goes on in the courthouse, subject to the rational basis review, the non-public forum analysis that you get in Adderley versus Florida. Well, it's been 3 hours, so I thank everybody for watching. I'm not going to go through all the comments and everything like that. I appreciate you all coming out and watching. The chickens say thank you for watching and have a great day.